Counsel, we'll now hear for the lawyer for Lime Lounge, Mr. Qualley.
Thank you, Your Honor.
And we'll follow our practice. Begin with your high school, please.
North High School in Sioux City. I guess we're the Stars, so go Stars. And that was back in 2000, so it's been a little while at least. So not too far away from Des Moines. But with that, may it please the court, counsel. Now, I'm honestly kind of surprised that we're here today because unlike the former case that just argued before the court, the case law on this, the legislature has been abundantly clear, very clear and precise in its terminology set forth in Iowa Code 123. And from the very outset of this case or this fact pattern back in 2016, it goes all the way back to, I had done research on this case and it was very clear to me from the outset that code sections such as Iowa Code 123-37, that the legislature provided itself with the exclusive authority to regulate in this area, both the taxing and the licensing area. And they've in fact made that very clear through their exercise of their police power in 123.1, where they say this is an exercise of the police power of the state. They could not have been more clear in this case that the state legislature intended the state of Iowa to be the primary authority in the area of alcoholic beverages. Now, 123.37 specifically states that a local authority shall not require the obtaining of a special license or permit at any establishment. So that to me, having known this process and having known that Lime Lounge had to get a conditional use process in the city or permit in the city of Des Moines, that there is no way around that, on two separate occasions, in fact, that it would be required to go through this process. And it was very clear to me from that very application, the conditional use permit application itself, as is cited in our appendix, that it says it's a conditional use permit for a business selling wine, liquor, or beer under Iowa Code or under Des Moines Municipal Code 134.954. Yes?
Did not require a fee to be included with it, would we be here?
Would. I think the fee is a very important aspect of it, especially in light of Iowa grocery, because the fee comes into play in a number of ways, but it's also the added step that's provided for in Iowa grocery. And I believe that it provides the city with a level of control and authority that is not provided for by the Iowa legislature. And in fact,
that argument go? Are you saying the city can't have any sort of conditions that would limit where alcohol can be sold within the city?
Absolutely not. I believe that they can definitely do that. And that's provided for in 123.39 subsection 2, where it says specifically what a local authority can do. And they have two main sectors or two main areas in which they can regulate in that area. It says that local authorities may adopt ordinances or regulations for the location of a premise. Now, there's a couple of important points there. First of all, local authority is defined in the Iowa Code. It's 123.3 subsection 26. It's the city council of any incorporated city. So the city council can absolutely create zoning districts, and they've done that. And we're not here contending that they have any, that they can't do that. They can say, you know, we're gonna have bars only in this district, or we're gonna, you know, ban convenience stores in residential districts. Obvious situations where they can go through a zoning plan, they can put it in front of the public, they can vote on that plan, and the city council can enact those things. They can absolutely.
Isn't your argument here then that this one just isn't reasonable? I mean, are we determining whether this ordinance is just reasonable?
I believe it actually violates the provisions of 123 and specifically that area, because what they've done in the city of Des Moines has done is they've actually enacted a conditional, they've made liquor licenses or bars and taverns illegal in the city of Des Moines. Blanket illegality in the city of Des Moines. And then you have to go and get a conditional use permit through the Zoning Board of Adjustment. Now, the Zoning Board of Adjustment is not the local authority. Now, you're adding an additional entity because you have to, they're basically the gatekeeper to get to the city council. And prior to going to this, and that's, as we've set forth in our brief, a month-plus long process, multiple documents, neighborhood meetings, and so forth and so on. Now, they're the gatekeeper. If they say no, the city council never even sees this permit. The state never even sees the permit.
will delegate to that body to issue this conditional use permits?
A couple answers to that. Yes, they can delegate conditional use permits, but a conditional use permit is not appropriate in this particular case because the Zoning Board of Adjustment is established under Iowa Code 414. It's not a city entity, and the state certainly knows that. The state specifies who the local authority is. It's the city council. And again, what's important here is you're adding an additional step. The city council is still the local authority that will end up approving or denying the liquor license and forwarding it on the council. Now you've added a second body, which is the Zoning Board of Adjustment. That's the gatekeeper. So first you have to go to them, get this approval, which can contain multiple special conditions and whatever they see fit. And until they say it's okay, the city council doesn't even know there's an application that exists.
23, allow room under home rule authority for cities to regulate, for example, noise ordinances. And isn't that where your client got in trouble with excessive noise violations?
Address that. So they have two.
If you won this case, would we handicap the ability of cities to regulate things like noise?
So there's a few different powers that are granted to the city. Of course, they have the zoning power that we've already discussed, but they always maintain the power of enforcement through ordinances. And in 12339, it specifically says this. It says, local authorities may adopt ordinances not in conflict with this chapter. Now, what's important is an ordinance is also defined in Iowa Code 362.216, a city law of general and permanent nature, not a special condition applied to one business here and a different business there. Now, in this particular case, I'll answer that question. The city did exactly that. They did use enforcement methods against Lime Lounge, and they went to the district court and said they're in violation of their sound permit. They're playing music too loud. They lost. The district court ruled on that case. The city didn't appeal. The district court said you're allowed to do exactly what you're able to do. That case is cited in our brief as well. The city did take that method. They also went through the method of the sound permit, and they said that you're in violation of your sound permit. They lost that case as well. And then finally, they went to the Zoning Board of Adjustment and said, well, we've got this tool that allows us to skirt due process. And we can simply say, we can make allegations, even though they've been disproven in court without any sort of appeal and disproven at the administrative level, we can go and say, we're going to pull this rug out from you. And if we determine at the board level, we can just take away your liquor license. And here's the thing. This isn't just something, a scenario in which I've made up in my head or, this is a potential issue. This is what's happening in this very case. Sue Ann Donovan, which was the zoning enforcement officer in the city of Des Moines for many years and is specifically mentioned in 134.954 of the municipal code, specifically said to my client in an email that's cited in our brief, should your business continue to have bands, DJs, and other forms of entertainment with amplified sound, I may take the conditional use permit back to the Zoning Board of Adjustment for reconsideration. If that happens, I will request the permit be pulled and thereby stop liquor sales. So a zoning enforcement officer is saying, we can go back to this Zoning Board of Adjustment, we can pull that lever and just say your liquor license is done. And the city is utilizing this as an end run around the due process clause. I mean, in this case, in this very case, that happened. Like I said, it went to district court.
A matter related to health, safety, health, welfare, and morals that affects the retail sale and consumption of alcoholic beverages. Why isn't that carved out under the statute? Why isn't that permitted?
Why isn't what permitted, Your Honor?
Tell what you just described.
It is permitted. Well, it's not permitted at the board level for individual conditions placed on individual businesses. What happens when it goes to the Zoning Board of Adjustment under the code, under the municipal code, is the Zoning Board of Adjustment can place whatever unique restrictions or considerations or whatever it would like to place on each individual business, not based on the land use. Because keep in mind, a zoning regulation is land use based. And as we mentioned before, or as I had mentioned before, that is not what's happening in a majority of this code section. It's not land-based, it's business-based. And in fact, 134.954 uses the term business 28 times in that 2-page code section. It talks about subsection B, subsection 1, the business conforms with conditions. Subsection B5, the operation of the business will not constitute a nuisance. It's talking about businesses. That's for enforcement. That goes to the city. Once, it has nothing to do with zoning. Totally irrelevant to the actual zoning cause here. And like I said, the city has enforcement powers. The city council can enact laws, and they have. In the city of Des Moines, they've acted a sound ordinance. And if they say, you know, let's say the East Village, for instance, if they say we can only have sound at a level of 85 decibels, completely understandable and acceptable.
Of Lime Lounge's liquor license right now.
Active and in use at this very moment. There's a case with the ABD that's most likely being held up by this case, I would assume, but there's no guidance on that. But it's still active and in operation as of today.
When that case proceeds, I assume that you could make similar arguments that you're making here. Is that right?
And as we've said in our brief, the petition that the way that the city has crafted this is basically saying that if you don't have this conditional use permit, we require all bars and taverns to have this. If you don't have it, then it's a de facto revocation of your liquor license. It's not determinant of whether you're a bad actor or anything. It's basically, we said that you have to have this thing. If you don't have this thing, then you're in violation of our ordinance. And as far as that goes, then you have to, ABD, alcoholic beverages agent, you have to revoke this liquor license.
I read the 2019 case, the briefing in the 2019 Court of Appeals case. It seems, I'm not going to say it's identical, but it seems pretty close to this case. And then there's probably going to be, or maybe there won't be, depending on how this case is decided, some sort of ADB proceeding. I'm going to guess you're going to make the same arguments. I guess my question is, what is the practical import of what we're deciding here when it seems like you've litigated this once, you're litigating it now, you may or may not end up litigating the exact same issues in the future. So what is it that we're deciding today?
To answer that question regarding the 2019 case, essentially that case was a certiorari action. So it was the only option to appeal a board's decision. And the effect of that case, you're right, there were similar arguments, and we developed this, you know, as we researched this, we determined things like Iowa grocery exist. But that case, the court was not within its power to determine whether the law was relevant, was legal.
Is this the appropriate time, I guess, to challenge the conditional use permitting system when the cup was originally granted in 2011? Your client could have at that time said, I don't need to get one of these because your entire system is preempted by the code and the zoning board of adjustment is unlawful. And then you get to the revocation proceeding, and then you kind of launch this collateral attack on the zoning thing. Now we have a third case. It just doesn't seem procedurally, I don't understand what it is we're deciding and how it fits into this licensing structure.
We're deciding, keep in mind, is not just for this entity. I mean, this is something that's persisting across the entire city of Des Moines. And the point of the legislature in enacting this, and in Iowa grocery, the court was very clear, is this uniformity, and it's not existing. Now, to answer that question specifically, to be perfectly clear, the property where Lime Lounge sits right now does have an active conditional use permit. They went back to the Board of Adjustment and got another one. That same very board with many of the same members said, yes, we'll give you a conditional use permit. So that property has one. The point of trying to comply with the code as it stands and also challenging that code as invalid, obviously, you know, look how long this case has taken. So it's kind of one of those situations where if you want to be in business, you need to comply with what stands, but at the same time challenge that and say, look, this is inappropriate. And not just for us, but for every business.
Conditional use permit?
2022, that was issued by the Board of Adjustment.
No basis for revocation of the liquor license if they have one. Is that right?
Argument. I'm sorry?
Case moot? If they have the permit, what are we arguing about?
This case moot because the fact is the city that we should not have been required to have. It's both the fact that we had to get it, still maintained it, paid the fee for it, and are still under the purview of that permit, which shouldn't be required and can't be required under the Iowa code. So, and again, it's not just for Lime Lounge, just even if Lime Lounge were closed today, that wouldn't make this issue moot. The fact is this case stands on its own in the fact that every single liquor license holder in the city of Des Moines that's opening a bar or tavern has to go and get one of these conditional use permits.
Everyone other than Lime Lounge is not before us. I mean, this is a case about your client, this particular client, right? And if the case is moot, why, we've got other cases to do this term. So what are we here for?
Case is moot at all, Your Honor. We have the conditional use permit still as it stands today. The city is still arguing in front of the Alcoholic Beverages Division that because the initial conditional use permit was taken away, the revocation should still proceed. They maintain that argument. In fact, we have initiated a case, a mandamus case, to force the city to acknowledge that new zoning board of adjustment or decision, and they will not do that. So they've maintained that case consistently with respect to that zoning board of adjustment agreement. So I believe my time is up. Thank you, Your Honor.
City Attorney? Go first.
I'm John Haraldson, Windham Area High School, Windham, Minnesota, 1983. And I know there are people back in my office saying, my God, I was born later than that. May it please the court, counsel. Again, my name's John Haraldson. I represent the city of Des Moines. Just a little bit of bookkeeping. I know this cuts into my time, but why there's an existing cup case. Lime Lounge did, for their new bar, Nightingale, same location, same license, obtained a cup in 2022, but they obtained the cup in 2022 several months after the cup that this case is about had been dissolved. So the issue in that was operating without a cup for a certain period of months, which is a violation of 123. That's before the ABD, that's been appealed, that's what's being heard, that's what their mandamus case involves. But this case, again, involves the right of the city after the appellate case and the original Lime Lounge Thunder and Lightning, I think it's 927 Northwest 2nd in the table, found that the city did have a viable and enforceable claim for a violation of the conditional use permit by Lime Lounge by violating the noise ordinance. They were given a hearing before the Zoning Board of Adjustment, which has been delegated that power under 134-954, passed by the City Council, to hear such appeals. And after a hearing where the public was invited and Lime Lounge was able to present their case, their cup was revoked. They didn't challenge it to the district court. It went up to the Court of Appeals. The Court of Appeals found that the city properly enforced or revoked that cup through the Board of Adjustment. What's important in this case, because I think Iowa Grocery is the, yeah.
1 second. So you went through kind of some of the procedural stuff, maybe that's not reflected in this record. I take it your position is this case is not moot because it has some sort of collateral consequence with a pending ADB matter. Correct. Okay.
Not present before this court about the why we're before the ABD in that matter now. However, this case did have a district court originally, a temporary injunction on it. It was reversed after hearing. Court of Appeals upheld the reversal that the city's conditional use permit as enforced as a land use law was permissible under the powers given to the home rule authorities under Article 3, Section 38A.
Let me ask another question. Why isn't that res judicata, collateral estoppel, something like that?
I think it's a pertinent question as to whether or not we're up here on that issue. I can say that in the Court of Appeals case, the original Court of Appeals case that started this and was issued in 2019, in their appeal, Lime Lounge raised the issue that the cup violated 123.37. But the court found that they didn't timely raise that, so it wasn't considered. Now, after the Court of Appeals decision was made, we and the temporary injunction was dissolved, we made an appeal to the ABD to begin that process. But this whole thing started because we were about to do that. So again, Iowa Grocery determines this, and I think there's 4 sections of Iowa Grocery where the Supreme Court foresaw this situation and why it's permissible. On page 680, of the Iowa grocery decision, quote, "The most important to the present case, the General Assembly gave local authorities the authority to adopt ordinances which govern, quote, any other activities or matters which may affect the retail sale and consumption of beer, wine, and alcoholic liquor, and the health, welfare, and morals of the community involved," citing 12339-2. The General Assembly limited this authority to ordinances non-conflict with the Act and ordinances that do not diminish the hours during which wine, beer, or alcoholic beverages may be consumed at retail. These were issues considered by both the District Court and the Court of Appeals, and found that the city's cup ordinance is 134-954, which applies to more than just places that sell alcohol, was constitutional and not, as Iowa grocery was, an additional administrative fee directly related to an alcohol permit. And
You know, there is sort of a, I mean, the fee kind of has a taste that is maybe a little bit troubling. If we were to find that the fee is preempted, but everything else isn't, could we strike down the fee alone? Is it severable?
Supreme Court, but I don't think that that would be a logical extension of either Iowa grocery or 123. You know, it's interesting, the preamble of Iowa grocery talks about how liquor has been an issue since the Whiskey Rebellion in 1794. But it also should be said, when it comes to considering issues of health, welfare, and public morals, liquor is the only act that we've ever had a constitutional provision prohibiting, and it lasted for 15 years until 1933. It has always been an issue of concern for the health, safety, and morals of a community. And the fact is that the Iowa Constitution gives cities, municipalities, local governments control over zoning. And they have the right to make sure that those establishments fulfill that duty. Now, when it comes to the fee, this is the same fee that a number of other conditional use permits for other activities pay. We might talk about what 123 prohibits for additional license fees and for, I believe, transfer fees, which I believe, which Iowa Grocery also said are the only two fees that are addressed in the statute. At the same time, recognizing 123.123.30 sub 2 and 123.39 sub 2, which allowed cities to enforce their ordinances. The 123 does not say that alcohol establishments deserve special privileges, that they don't have to pay a conditional use fee that someone developing in a flood zone has to, that someone putting a telecommunications installation has to, that someone with a non-conforming use has to. Those people have to pay fees.
Grocery was distinguished by the Court of Appeals on the fee issue because in that case it was attached to the application for a liquor license. And here it's the fee is for the cup that involves a number of issues. Okay. Is the challenge raised by Lime Lounge, is it express preemption or implied or both?
Appeals assumed it was express preemption, but no matter what level of preemption it is, I don't believe that they have made their case. Again, under express preemption, the Iowa 23 makes special exceptions for what local communities can do and enforce the ordinances, including passing ordinances and regulation.
Address opposing counsel's argument that when those zoning ordinances that they're talking about are permanent land use, and so that needs to be tied to the land and not to individual businesses.
The conditional use permit is tied to the land and whether that piece of land can be used for selling alcohol.
To a specific area of land, or is each parcel of land treated differently?
Each parcel of land is not treated differently. If you want to put a liquor establishment on a particular parcel of land.
As far as like the ordinances, is there an ordinance that says in this block of East Village, you know, this is what the noise ordinance is, or is that, or those ordinances applied parcel by parcel?
noise ordinance. Now, within the CUP, over the course of several years, there's negotiations for particular entities, and I believe both the district court and the Court of Appeals addressed that. You can find minor differences, but they basically are all cohesive with the sound ordinance. And that the court applied the equal protection sense there, which is rational. And it's rational to have that sort of control and implementation for land use in a mixed residential area, as this area is. It's downtown in Riverside district.
More crack at this, issue that Justice McDonald first raised about, these multiple proceedings and multiple bites at the apple. I mean, my understanding, so there was a revocation proceeding for the conditional use permit, and that went all the way up to the Court of Appeals, and they tried to raise the preemption argument in that case? And the Court of Appeals said, too late. You raised it too late. And that's a final decision precedendo issued. So then there's now an effort to revoke the liquor license, and now they're arguing again that the conditional use permit is preempted. Why? I mean, I understand there's no issue preclusion because it wasn't actually litigated, but why not claim preclusion? Claim preclusion applies to any claim that could have been raised in the prior proceeding where there's a final judgment.
I don't disagree with your analysis. I assume that my respective colleague will. But I think that their argument would be that because of the nature of the appeal, the certiorari petition, that issue couldn't be raised, although they still raised it. And the court found that it was raised too late. When we went back...
Why couldn't it be raised in a certiorari? I don't understand.
I can't honestly say that I've researched that issue. I don't know. I think that there probably was an issue whether it was raised in the district court below and whether they could bring it up as a new issue.
Is claim preclusion in this appeal as an argument?
Feel that Iowa grocery is, and the way that the city's actions are consistent with 123.39 and 123.30 sub 2. We did not raise an issue preclusion argument specifically, no. I believe that, and again, an important distinction that Iowa grocery makes is, and it should be said, there's some attack on conditional use permits. Well, the purpose of conditional use permits is to permit the provider for flexibility in what otherwise would be rigidity of zoning ordinances, while at the same time controlling troublesome aspects of the somewhat incompatible uses by requiring certain districts and standards. And that's W.G. McKinney, Farms versus Dallas County. So I don't believe that this should be a valid attack on conditional use permits. But what specifically Iowa Grocery stated is that on page 681, they state that the only other fee addressed by the legislature, other than the application fee for a liquor license, to alcoholic beverages is the license transfer fee. That indicates that other matters regarding land use, such as 134.954, are within the province of the police powers of the local government, which is what we have here.
Why did it take over 2 years after the temporary injunction was issued to get a district court judgment?
It had something to do with it. It was also, I think there was a shuffle. I know that the district court judge we have below is not generally in 5C. So I don't know why it took 2 years, to be honest. But it did. And it should be noted, the temporary injunction applied while it was in force. So there have been several litigations involving this issue. This is, in many ways, a reprisal or a rehash of what happened in that came out in 2019, with the additional twist of, well, now it violates Iowa Grocery. But the thing is, it doesn't.
Hypothetically, if we affirm, you win this appeal, then you still have, before the Lime Lounge is shut down, everyone waits for the ADB agency ruling, or what happens next?
Due process rights under the ABD into this matter. There was a hearing in front of an administrative law judge, which held the city's action, then it got appealed. It's been in abeyance, but fully briefed by both parties since. There's no guarantee that Lime Lounge won't win, that the ABD won't determine, well, they may have violated the noise ordinance, but that's not enough to suspend their liquor license. Then there's another matter before the ABD over the issue of how long they went without a liquor license, which again is not an issue here, but there's due process there. And by the way, they won before an administrative law judge on that one. So there are various legal proceedings still pending. There's their ability to maintain their liquor license is being followed through the normal process of an ABD complaint where they have due process for hearing.
And they're currently operating under the name Nightingale or a,
The license is unchanged, but the business name is now Nightingale.
if they lose both ABD appeals or proceedings, then what happens?
Determine their punishment. And that may include revocation, it may include a fine.
And in the interim,
As they have throughout this entire process that is now 8 years in the making. Back when I could talk about when I graduated in my office, wouldn't snicker. So it has been ongoing for a long time. But a clear reading of the statute 123:30 sub 2, 123:39 sub 2, and the decisions below, and Iowa Grocery will support that the city has properly instituted this program and it does not violate 123. I thank the court for its time.
Thank you, Your Honor. Now, I'd like to start by just kind of mentioning what Mr. Haraldson said is that, there have been multiple cases in this, and that's accurate. The fact is, in this case, the original district court hearing that the city brought, or the enforcement action that they brought, claiming that Lime Lounge is in violation of a noise ordinance, when we won that case and they didn't appeal, it should have been over. That wasn't our choice to proceed on that. And then they brought administrative actions because they lost in that case and they were upset about that. And those actions lost. It should have been done at that point. The fact is, we're here not because we want to fight this case. It's about an alleged loud music on a couple of occasions by people that complained. But the district court found that we had a permit to do that, and it was legal. And it should have been done at that point. The city didn't respect those decisions. And then it utilized this conditional use permit process to circumvent that whole system and use those exact same allegations in front of the Board of Adjustment and then get a different outcome.
issue preclusion in this appeal, in this case?
Issue conclusion? I don't believe we did in this case. We argued primarily focused on Iowa Grocery and its application to this, in obviously Iowa Code 123.
Are you relying on express preemption or implied preemption, or both?
Well, it could be both as well, but I believe definitely express preemption.
What was Iowa Grocery? Wasn't that implied, or?
I believe it was express preemption because, I mean, they cite, there are certain parts of this where, especially the imposition of the police power. I mean, the Iowa Code 123 is very clear in their exercise of their authority over this issue. And it's very clear and very overwhelming. I mean, that's, we have to get away from this general view, which, the lower courts have adopted of home rule authority. There's not a general broad view in this particular case where the legislature has been abundantly clear that they want the authority. And they're only granting specific allowances, specific authorities to the municipalities. And one of those is certainly, as I mentioned before, is enacting consistent zoning regulations, is enacting ordinances. And they have done that. But you can't do it on an individualized basis for one business to the next. Now, as far as the
argument, and I guess why can't the city, as part of the zoning process, look at the conduct of the business and decide whether additional permitting is going to be required or that the business could potentially be a nuisance? I mean, you can imagine a light industrial area where you have a factory, belching a lot of smoke, and the city might say, this is not an appropriate use for this particular parcel of land. It seems to me a big part of zoning is regulating the businesses within a zoned area. So I don't understand that.
Whole, but what we have in the city of Des Moines is if you were to say, look, let's say downtown district, let's say it's, bars are allowed in the downtown district, right? You can put them there and, you have to obviously abide by the laws of the city, but you can put bars there. But you can't put them in this area. And if you want to go in C3B, for instance, then you need to go to the Zoning and Board of Adjustments and ask for an exemption to that. And maybe in that case, there are restrictions that are placed on that. But that's another question. But the fact is, they don't have any of those districts in the city of Des Moines. There are no districts. Every single tavern and bar is outlawed in the city of Des Moines, and every single tavern and bar has to go through this conditional use permit process. So every single tavern and bar is placed with special conditions and special considerations. And while Mr. Haraldson tries to minimize those as if they're just slight variances, I mean, our very establishment, we were the only people in the East Village that had a patio because the Board of Adjustment said so. And is that fair? No, it's not fair. If we had a patio in that zoning district, everybody should be allowed a patio. Different bars, neighboring bars had different restrictions and requirements. And we've set that forth.
This review of your equal protection claim is very deferential. What's your best case that you can prevail on a constitutional equal protection argument?
Protections is, I guess, we're relying more on Iowa Grocery in this case because I think they address that more in, specifically in a couple of the areas, but your uniformity in one of our provisions that we set forth is very important. And the Iowa Grocery Court sets that forth, that uniformity across jurisdictions, that you can go, that the city of Des Moines, for instance, isn't enacting certain regulations that pushes people to a different jurisdiction. And the reason for that is obviously Iowa wants liquor sales. They want the revenue from that. It's a liquor control state. But they don't want one city to bear the burden over that over another city unproportionally or disproportionately. They want that to be borne across the jurisdictions uniformly. And that's not what's happening here because people go to different cities for different reasons. Oh, sorry, my time's up. Thank you, Your Honors.
Lime Lounge Inc. versus City of Des Moines is now submitted, and the court will adjourn for the morning.